Gentleman yields back. Now the chair recognizes himself for questions. Ms. Salgado, there's been an issue, and we brought this up here in this emergency issue of provisions, emergency disclosure mechanisms. And Mr. Littlehale, actually, in his written testimony, that the primary emergency disclosure mechanism currently in law are voluntary. He also mentions that companies are often, in his words, unable or unwilling to respond to law enforcement's lawful demands in a timely manner. Now, I think we all would agree true emergencies are there, and as a son of a Georgia State Trooper, there's not going to be anybody that would deny the need from a law enforcement perspective. However, it seems to be implying that there's something missing here. So we did a little bit of research in our office and with others, and based on the concerns that we saw, that published in Google's transparency report, based on that report, which we've looked at, it says Google received 171 emergency disclosure requests and provided at least some data in response to 80% of the emergency disclosure requests. One, I think for most people to understand it, we've looked into it, but I'd like to hear your answer to better understand that. Can you explain why Google responded to only 80% of these requests, break down those numbers for us, and why couldn't the response rate be 100% given what's been heard by Mr. Littlehale here?
Sure, I'd be happy to. I think the statistic you're referring to is in our transparency report. We've been publishing that number for a while here so that policymakers and others could get an idea of what this work is like. The number is actually relatively low, 171 compared to the type of legal process we get. The 80% represents lots of different situations where the emergency doesn't justify the disclosure. Often the case is that the identifier that's given to us in the emergency request doesn't actually go back to any real account. So there are some services out there where you can create an account using a Google or any email address, and it's not verified that there is such an address. They may use that account to threaten a school shooting or engage in some violent activity. The authorities quite legitimately will come to Google and ask us for information about this account that was used to create the account that made the threat. We look in our system and there is no such account, so the response back is we have no data to produce in response to this otherwise legitimate emergency request. That gets counted as a non-disclosure, and that adds into the 20% where there was not a disclosure. There was no responsive data. That's probably the most common situation in that 20%. There may be other situations where the request is coming in and the emergency is over, that the investigation is now actually about a historical crime. There is no ongoing threat to loss of life or serious physical injury, which means it's inappropriate to be using that authority to get the information. And we are able to, at that point, say this doesn't look like an ongoing emergency. We can preserve the information, and when you come back to us with the legal process, we can promptly disclose.
Okay, and just real quickly, but you went on with your answer long enough to bring up a question. Are you making that determination if the emergency situation is still ongoing?
That's right. The statute...
Not the law enforcement agency offering.
The statute says that we are allowed to disclose if we have a good faith belief that there's an emergency.
Okay. Mr. Littlehale, when you testified before House Judiciary Committee in 2013 about the emergency disclosure issue, you said that some providers make a decision never to provide records in the absence of legal process no matter the circumstance. Can you identify the service providers that have a policy of categorically rejecting emergency requests in the absence of compulsory legal process? If not, why?
Congressman, as I stated in response to the question at the time, I have made a decision not to identify in the examples that I give specific providers because I don't want to highlight a vulnerability in a public forum. There may come a time when we do.
Well, I'll tell you what, I'll
that.
make a request and you can submit that in a non-public forum, but I'm really concerned here that we're making a categorical statement without categorical proof.
Well, I can certainly say anecdotally that
no, I want to know, you made a direct statement.
Have been told that by providers.
Mr. Littlehale, you made a direct statement. It wasn't anecdotally. I didn't start off by saying anecdotally providers make a decision never. You said in your testimony, providers make a decision never to provide records in the absence of legal process no matter the circumstance. Now that's a very direct statement against the business practices of internet providers. Is it true? Is it not true? Do you have evidence or do you not have evidence?
I have been told that by providers, yes.
So you don't have evidence. You made a statement that is not grounded except anything in anecdotally.
Well, I would suggest that I do have evidence. I have been told that by providers.
Well, I was told that there was a Santa Claus, but I found out real quickly there wasn't.
Well, Congressman,
I'm trying to figure out
I would suggest that that's evidence. If you choose not to believe me, then I suppose I can't help you with that. But I have been told, and agents that work for me have been told that in some cases.
I'll just let that one sit. Mr. Aronese, I want, during an exchange with Senator Leahy in a Senate hearing on this topic, you said that with regard to phone calls, you're not seeking authority that criminal authorities have that civil agencies do not. But in seeking to get access to emails without a warrant, you're essentially seeking something more than the authority that criminal authorities have. Isn't that contradictory?
I don't think we're seeking more authority than the criminal authorities have.
So what are you seeking?
I'm sorry?
Then what are you seeking? I'll give you a chance to clarify that.
Sure. What we're seeking is the ability to obtain emails after we try to obtain them from an individual subscriber by going to a court and obtaining a court order with notice to the subscriber and allowing the subscriber to raise whatever objections they have before the court.
Well, I think, like I said, it's interesting that some of the testimony that's been given here, and I think, it's very concerning from some issues of anecdotal evidence and real evidence and discussions, especially on the SEC side, when you're, giving the, your own report saying you're doing more than you've ever done here, yet without this by choice or decision, however you want to do it. Mr. Calabrese, one last question for you, as my time is now over. But in dissent from the FTC request of civil agency carve-out, FTC Commissioner Brill wrote, "I am not convinced that this authority is necessary to maintain the Commission's effectiveness as a law enforcement agency now or in cases that we can presently foresee. On the other hand, I am concerned that the judicial mechanism for civil law enforcement agencies to obtain content from ECPA providers could entrench authority that have potential to lead invasions of individual privacy and under some circumstances may be unconstitutional in practice." Could you speak very briefly, do you agree or disagree with his concern?
I do worry that we will create an unconstitutional or incredibly reckless carve-out for civil agencies, and my hope is that we continue to push H.R. 699 forward as is to a markup, and we can vote and get it to the floor. Thank you.
Well, I appreciate it. And so looking around and seeing how it's just me and the distinguished ranking member, this concludes today's hearings. I'd like to thank all the witnesses for attending. Without objection, all members have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. And with that, this hearing is adjourned.